refused to show up in court. Their own volition. Reason being, they were dressed in t-shirts with political slogans, which is a dress not acceptable by prisons. So they were offered options, either to take on clothing that prisons had offered them that they received from donations, or to send for clothing from their relatives to change into something appropriate for court. This they also refused to do, saying that they'd rather show up here naked than be dressed. Now the court of course shall not condone attending to accused persons who are not dressed. So on their own volition they refused to show up to court today. And that being the case, we cannot hear their bail application there. I'm going to give another date to allow them a chance to find appropriate clothing.
Maybe before you take it over, you inform us that it was on their own volition. Then you tell us the issue was dress code. And this is a court of, I don't know, underpart law.
If they give an option to change into something and they are refusing, that is their
Your
own
Worship,
volition.
Your Worship, if I may, kindly, you inform court that it is administrative within prison not to put on shirts with political slogans. They are coming to court, not to prison. I do not know if court also has a dress code. Our interest is them in court. They could have been naked all through in prison or in yellow, but for purposes of court, does court have reservations as to whether someone can come in t-shirts with those slogans? We need a pronouncement.
You did not get my communication
Your Worship.
clear. We both can't be talking. The communication informal that I received from prisons is that these accused persons have deliberately refused to dress up into something that is appropriate according to prison for them to be brought. I have no problem with how they dress up. I have no problem. But I'm not the one responsible for producing them. It is the prison authorities. They've given them opportunity. Change into this clothes, given you donation. Send for other clothing, they have refused. The alternative, they say, we either show up here in our t-shirts or we show up naked.
Your Worship, my prayer is court pronounces itself on whether it is in order, it is right for prisons to refuse to bring someone because they cannot put on something which is allowed in court but maybe not allowed in prison. Our interest is in court. They could come in their yellow uniform, but for purposes of appearing here, they could put on whatever they want. If there is any bar by law, if there is any bar by law, Your Worship, inform us.
Advise them, they are your clients. I would advise, I would give guidance. Advise your clients to dress up into something that is appropriate for the prison authorities to bring them. I am here all day to listen to their application.
Your Worship,
once they are open to that, we can always have
Your
the
Worship,
matter.
maybe for clarity, is it the position for court? Pronounce yourself and tell them, no, the t-shirts are fine in my court. Bring them as they are. We shall not deal with the wishful thinking of the state and prisons. Court must protect the people.
The court is protecting them by advising them.
Your Worship, Your Worship, what is rubber stamping the wishful thinking of the state and
But
prisons?
anyway, in the absence of accused persons, my job is to have the case as trial. With them not being here, is nothing much I can do. Are the relatives of the accused persons present? Where are the relatives? Where are the relatives?
So if the prisons feel that given attire is not appropriate, it's their regulations. So you know that should be clear, it's their law. The Prisons Act is clear. They are subject, so they have to adhere to what prisons determines.
I wish we had a prisons officer put on record. They give that reason on record. We know it is from ASP, this, from Luzera Women's Prison. Then two, if the state is referring to any law that bars people from dressing the way they wish en route to court, not within prison, en route to court and in court, let him deal court. Otherwise, it is wrong for him to misguide court, saying the act is very clear. Which act? That notwithstanding, Your Worship, we make a prayer that if indeed prisons was unable to bring them earlier in the morning, for whatever reason, their own volition or prisons inaction, we pray that the matter is stood over until 2 and court makes an order to produce them. We shall devise means of how to dress them. If court says they cannot appear in those shirts, en route or in court. So we make a prayer for a short adjournment or standing over the matter until 2 for the accused persons to be produced in court, or in the alternative, they could appear on Zoom if it is the better option. But the liberties of the accused person are very paramount, and they cannot be constrained because the state wishes, because the prisons wish. We would not be proceeding right if we upheld their wishes against the liberties of these persons. We so pray the worship.
With that being said, I want to give a standover, but I can't give a short adjournment. For them to appear here and we'll handle their application.
So it is a thin line.
You can verify with them.
They are my clients. I don't know whatever you're telling me. There's no prisons officer to inform us. No formal communication.
It has been a deliberation on the 10th of March is available. If they are willing and able to adhere to the prisons regulations, they can already produce here for their application. At 10 a.m.
Your ship is available, but maybe we would pray that if you can, make a pronouncement as to the place of the court to prisons. They cannot continue to abuse inmates, abuse suspects, and all the court does is condone adjourn. Let court pronounce itself.
And so for avoidance of doubt, I am only adjourning the matter because the accused persons are not in court. It's nothing else. Don't turn it out to be anything that it is.
If it happens again and the only